Today we're broadcasting from Berkeley. We're here because it is a pillar of the tech and life sciences startup ecosystem of the greater Silicon Valley. When you think Berkeley, you think innovation and entrepreneurship, and I think startups.
Welcome to another edition of Ask a Silicon Valley Lawyer. I'm Louis Lehot, and today we're going to talk to you about the size of your option pool and option grants. And to help illuminate this topic, I've invited my good friend, Nicole Hatcher, to join us today. Nicole?
Thank you, Louis. I am Nicole Hatcher.
Nicole, I'd love to get your thoughts on option pools at formation. Is there a rule of thumb about what size they should be as a percentage of the authorized capital?
Yeah, I would love to hear your thoughts as well, Louis. What I'm seeing with my clients is some clients think that they can get away with no option pool at formation. I don't think that that is a good idea. I think you need some option pool in place because early on you're going to want to hire. You don't want to either amend the charter to provide for more shares of common stock that you want to issue, or otherwise take dilution outside of the pool. And there's built-in securities law exemptions. But so I would definitely say set an option pool at formation, and I would typically see around 15 to 20%, but let me know what you've been seeing.
I always recommend 20%
Yeah.
of your total authorized equity to be set aside for an option pool. You control at formation how much capital is actually issued,
Right.
and you control the option issuances that are going to be made thereafter. So sizing a nice, healthy, large pool that's going to be sufficient to take you through the early stage, seed stage, and then A round, I think is really helpful and in reducing cost.
Yeah. And so what do you see, what kind of option pools do you see at an A round?
I typically advise my clients, both entrepreneurs and investors, to make sure that in between the A and the B round, that they have reserved enough equity to fill the hiring plan that's going to be required between the A and the B, which is sometimes a 2-year period. And so, if you know you're going to be having to bring on a chief marketing officer or a VP of engineering if you don't already have one, or a group of data scientists, I want to make sure that all of those people have enough equity, and then I want a little bit of cushion in case I want to dig deep for some really great hire, or if there's an acquisition that I'm thinking about that might require some incentives for employees. And so I think that you should tailor it to the size of equity that you're going to need in between the rounds.
Really? So what would you say, I know some of our founders, when they're negotiating their term sheet with a venture investor, they want a smaller option pool because it means less dilution for the existing holders, and the investors generally like a larger pool. What would you say to a founder when thinking about negotiating that, or thinking about the size of the option pool when they're negotiating with their investor?
I think there's a lot of give and take, and there are a lot of levers of value to press on in a term sheet negotiation. And what I always remind my founders is that they're eligible to receive option grants from the pool. And if the option pool is not used in between the A and B, then maybe they can top themselves up in exchange for perhaps giving on some other points. And so I don't think it's a point that founders and entrepreneurs should fight back on, as they always have the ability to receive some of that equity out of the pool, particularly if they're outperforming.
Can you tell me a little bit about what you need to prove options or common stock issuances under the plan?
So that's a great question. First, you need a plan, an option plan that is approved by the shareholders, which we said we can do at formation, and then we can amend and restate as we go, or we can adopt a new plan, which is typically named after the year that it's adopted. Next, in that plan, there will be a series of appendices for the types of grants that will be granted thereunder. So incentive stock options, or ISOs, non-qualified stock options, or NSOs. There could be restricted stock units, or RSUs. There could be restricted stock awards, or RSAs. There could be just stock, right? So you want to pick the appropriate attachment, which is an option agreement, and have the optionee sign it, and it should have the vesting conditions set forth therein, and it should have an exercise price. Before you grant that option to the employee, the consultant, or the service provider, and it must be one of those three persons in order to benefit from the appropriate treatment of the tax rules. You're going to want to have the board approve the value of the exercise price, which should be granted at fair market value. And there is a safe harbor under the Internal Revenue Code, Section 409A, which says that if you adopt a third-party valuation once a year, and the board approves that valuation, then the board can typically rely on that third-party valuation report. We call it the 409A, to know what the fair market value price is. It should be approved at a live board meeting if possible. That is the best practice. If out of cycle grants can be made in between board meetings by unanimous written consent, but after the scandals of the mid-2000s and the backdating issues that occurred where the signatures were manipulated to go back in time, we try and always have options granted during live meetings. It isn't a legal requirement, it's just best practice, and that's what I always recommend, is that they're granted during those meetings, live meetings. And right after that, you would issue the option through CARTA, hopefully, or some cap table management program, as we were talking about in our last video blog, Nicole. We would want to make sure that we got a signature from that service provider to the option agreement. Last thing is, we always want to make sure we know how much equity has been granted under the plan for securities law purposes, because we're granting equity to employees under the federal securities laws under Rule 701 of the 1933 Act, and that requires certain disclosures be made to each employee upon grant and at exercise, and that depends on how much disclosure is made, depends on how much equity has been granted in the last 12 months. So that's really important to be tracking.
Okay. Thank you, Louis. I really appreciate it.
Thanks so much for joining us on our latest episode of Ask a Silicon Valley Lawyer. I'm Louis Lehot. If you have any questions, don't hesitate to reach out to me.